Good morning and welcome to Backchat. I'm Hugh Chewett and your co-host today is Andrew Work. Andrew, good morning to you.
Good morning, Hugh. Ready for action.
That's the spirit. We're going to be talking today about the ruling on pro-independence activist Andy Chan Hoi Tin, his election petition. Legco hopeful was barred from standing for election in 2016 as the returning officer judged he was not sincere in signing a pledge to uphold the Basic Law. His party had been widely reported to not recognise the Basic Law or one country, two systems. Yesterday, a judge ruled that returning officers do have the statutory power to look beyond formal compliance to application forms in deciding the candidacy of election applicants. What do you make of the judgment? What are the implications for other related cases where people have not been allowed to stand, including, of course, in the forthcoming by-election? Email us, backchat@rthk.hk. You can go to our Facebook page, that's Backchat on RTHK Radio 3. Comment there. Call us on 233-88266. 233-88266 is the number. After 9:20, we're talking about blood donation in Hong Kong. Joining us for our first topic, we have with us now in our central studio Wilson Leung, who's a member of the Progressive Lawyers Group, Michael Davis, former Professor of Law with the University of Hong Kong, and Lawrence Ma, who's a barrister and chairman of the Hong Kong Legal Exchange Foundation, will be joining us very soon, we hope, and Andy Chan himself from the Hong Kong National Party will be joining us, we hope, after the news at 9 o'clock. Mr. Leung, good morning to you.
Morning.
What do you make of the ruling? What do we gather from it?
I think it's mostly gloomy with a small sliver of hope. Now, it's gloomy, of course, because of, as you've summarized, it establishes for the first time that the returning officer does have a power to assess and to disqualify candidates based on an alleged failure to intend to uphold the Basic Law. And it's the first time it's established that the returning officer has such a broad power. Previous to that, it was assumed that returning officers, their role is to check the forms, check the age, and so on. But it's the first time that it's confirmed by a court that returning officers actually do have this power to make an assessment. So that's the gloomy part.
Yeah, so they're the prosecutor and the judge now.
One can use that comparison. Mm-hmm. They consider certain things that they consider are evidence. They ask some questions, and then they make the decision.
Right, and if they want to, they can go to the EXCO member of their choice for select guidance, as we have seen recently. Like the Secretary of Justice.
Yes, they can go take advice from the DOJ, and that's another worrying aspect.
Mm-hmm. Why is this worrying? Why is this gloomy?
I think it's gloomy because as Hong Kong residents, we already have significant restrictions on our ability to vote for candidates. We know the problems with the functional constituencies. We know the ongoing problem with the lack of ability to vote for the CE. So we already have quite a few restrictions already on how we can vote for our representatives. Now, this adds one more. This is basically saying at the nomination stage, we have a person called the returning officer who will remove certain candidates from the slate that is presented to the voters.
And that's kind of your classic dictator's move, right? Yes, we've got an election. It's just, these people didn't qualify.
I would say it removes significantly the ability of us, the public, to vote for who we want.
Okay, how about the silver lining? What's that?
The silver lining is that the judge said it's only in a clear, compelling case that the returning officer can disqualify. So the standard is set high, according to the judgment. And the second silver lining is that it says the returning officer has to give an opportunity to the candidates to respond to what the returning officer thinks. And this may provide some silver lining for the candidates who were disqualified recently in the by-election.
Okay, it was pretty clear and compelling in this case, wasn't it? In that was, as I understand it, correct me if I'm wrong, the stance of the party was that they would not uphold the Basic Law, and he was standing on that platform. And if if the point of taking part in Legco is to uphold the Basic Law, there's an obvious contradiction.
Yes, I mean, this one is probably at one end of the scale of clarity. The questions would arise when someone does something that falls short of what was done here. For example, Agnes Chow, self-determination. There's going to be huge questions about whether that's equivalent to what Andy Chan did in this case.
Yeah. What do you think also about the way that I was quite interested in the way that the judgment incorporated the interpretation of Article 104 and also the background, the explanation of the interpretation of Article 104. What did you make of that?
Yes, basically it works backwards. It connects the two things. Basically, it's reiterates that the oath requirement is a substantive requirement, they say. So it's not something that you just have to say. You actually have to believe in it. Then the judge worked backward from that to say, well, if at the point of taking the oath, you have to actually believe in it, then at the earlier point where you have to confirm that you will uphold it, then you must also do it. Because if you, even at the nomination stage, you can't convince the returning officer that you will, then you won't be able to do that at the oath stage. So what's the point of letting you stand for election if at the oath stage you're not going to be qualified to take the office?
I mean, you said this is gloomy. Could you say it's enlightening? This clarifies things. This makes things a little bit more apparent how this is going to work.
Well, it certainly clarifies things in terms of it adds support to what the government has been trying to do, but so far without any legal support in terms of a judgment, because they've been disqualifying people in the the returning officer has been disqualifying people in the recent by-election, even without this recent judgment having come out. So now it does provide some support for what the returning officer did in the recent by-election.
Lawrence Ma, barrister, chairman of the Hong Kong Legal Exchange Foundation, is with us now. Mr. Ma, good morning to you.
Good morning, Hugh.
Thanks for joining us once again. What do you make of the judgment?
Well, I think the judge is legally correct. I mean, the precedent that he cited are clearly binding on him. There are numerous Court of Final Appeal judgments that he cited which are binding on this judge because he is a High Court judge. And the precedent he cited has clearly stated and supported the conclusion he finally made. For example, the reasonable restrictions on the right to vote. I mean that the right to vote could be reasonably restricted if it is if a proper basis is provided. That sort of thing. It is quite a tight law. That means he doesn't have much room to maneuver. Unless he wants to because of the doctrine of precedence, those precedents are binding on him. But overall, on reading 140 odd paragraphs of the judgment, it seems that he is legally correct in coming to the conclusions he's now come to.
No, they can come to the conclusion they come to saying the law as it stands says this can be done. They're not really providing a prescription as to what the law should be. Is that right? They're just saying the law as it stands. This is what it says.
Yes, because what the judge has interpreted the provisions using the purposive approach, which was an approach used by the Court of Final Appeal since the Ng Ling days in 1999. So that's why I'm saying he hasn't got much of a room to maneuver.
And so it's up to the government and the legislators to decide if they want to change that, if they want to make things more clear or change the qualifications.
Well, I mean, you can't change the judgment. You can change the Legislative Council law, but you can't change judgment. Judgment has to be set aside by the court themselves.
Mm.
Well, what do you make of the point that was raised as a silver lining by Mr. Leung that the judge said there must be clear and compelling evidence that the person does not intend to uphold the basic law? Do you think that's fair? Do you think that's right?
Well, I think that's true. I mean, the returning officer has to make his or her decision, which is an administrative decision, based on substantive evidence. If there is evidence to say that the person doesn't comply with the legal requirements, and that sort of evidence has to be based on a fairly cogent standard of proof, which is it has to be on the balance of probabilities that the person does not comply with the legal requirements, which is, for example, in this case, upholding the basic law and swearing allegiance to the SAR government. So if there is evidence to prove to the satisfaction of the returning officer, then that person, the returning officer, can make a decision based on these evidence.
Does this put too much power in the hand of that person who, has other job responsibilities within the government, is part of a chain of command that leads all the way up to the chief executive, worried about their career prospects? I mean, is that too much power for one person at a relatively low level and other responsibilities to bear if other people are going to have interests in what their decisions are?
Well, I'm not sure whether that low level comes in correctly, because I mean the returning officer is a director grade 2 senior government official. I mean, if he's not an uneducated person, for example, a government cleaner or something like that, and that would be answer to that. And the second answer to your question is that whether there's too much power given to him, well, he can't decide, because the law, actually under Section 40 of the Legislative Council Ordinance, actually gave him a sort of considerations to consider. And one of them is whether the person upholds the law. Now, and whether, for example, that person has an extra nationality, for example, or been convicted of certain offences that should disqualify that person from being elected. Now, there are lists of considerations that an administrative officer in the shoes of the returning officer that he has to consider before he makes a decision. So there's a basket of considerations inside Section 40 that he has to consider. So once he has considered that, and he has to formulate a decision in writing and giving reasons, so that that decision could be subject to judicial reviews subsequently. So if I'm not, so you can't be saying that it would be too onerous on him, because that if you feel that position, that's the legal requirement of a person exercising powers in their position.
Yeah, I'm saying, should it be switched out to somebody maybe who's independent, who doesn't have career considerations and political considerations, above and beyond what their decision is?
Well, I would say that you can't say that he's making a decision based on political considerations, because all the considerations are laid down in many words in Section 40 itself.
I guess that if it's a question of nationality, or if it's a question of previous convictions or something like that, it's a very obvious yes/no kind of thing, and you can tick a box. When it's a question of interpreting the intention of somebody, that's more complicated. That's not something that an administrator generally does.
Well, it's not something of a future intention as it bears in the judgment. It is something of an existent, a present tense requirement for the person to uphold the basic law. If you read the judgment, so evidence based on the person's statement could be used as evidence. When the returning officer is forming his decision. So that would be something that a decision could be made. Now, but in any event, if a candidate is unsatisfying with the administrative decision, he can always seek judicial review of that decision.
Okay, Michael Davis, good morning to you, former professor of law at the University of Hong Kong. Thanks for joining us. Your thoughts on the judgment?
Well, I think what you've heard from my colleagues here this morning is pretty much accurate. They've summarized nicely what the judgment reached. And in terms of international human rights and free speech, it also went into that in the case. They referred to the McGuinness case in the European Court of Human Rights. And that case was with the government as well. It involved Jerry Adams taking up his seat in Parliament, and it was kind of an oath-taking case, swearing allegiance to the Crown. So it seems that's all there. My concern, I think, is that, Hong Kong's reputation with all of these cases of disqualifying legislators and so on, I think the reputation of Hong Kong has really been damaged globally, and really the trust of the public in the electoral system is also, I think, in a bit of a bad spot. And so I would think one option going forward would be, because of the questions you've asked about whether a review of, a returning officer should be exercising so much power, would be to put in place some kind of expedited review or appeal to the judiciary. And nothing like that's been discussed, that we never had this fully elaborated as to the power of the returning officer. Many people expressed concern that, as your question a moment ago did, that this seemed like a lot of power just to disqualify people, and our government seems inclined to do that when any of the candidates have raised questions about self-determination or whatever, independence. And so it is nice that in paragraph 80 of the decision, the court laid out clearly that the presumption is, if you fill out the forms, that the declaration is legitimate. I'm sorry, cough here, and that presumption is binding on the returning officer unless there's clear evidence contrary. And of course, in the Agnes Chow case, she was not given a chance to explain her position, and I think she would have under the principles laid out in the case, a good case for appealing. So all of that being said, I think having somewhat review process would be a kind of reform that would be very helpful to restore confidence in the system.
Yeah, isn't this part of the problem is that the returning officer, they're not allowed to call witnesses, or they don't have the power to call witnesses, so all they can go on is public statements by the candidates, Wilson? Is that something we've seen?
Yeah, I think that's a problem. The procedure is pretty amorphous at the moment. We've seen the returning officers look at the candidates' Facebooks, looking at their YouTube videos, looking at different statements, putting out a few written questions, but it's not clear this is a very satisfactory process, because you look at the videos that you choose, and then you pose certain questions. They give certain answers, and then you say, okay, well, despite you saying this, I'm going to reject your explanation because of the YouTube videos I've watched. It's not clear that this is a very satisfactory explanation. When you haven't even seen the person, he hasn't had an opportunity to explain himself in front of you. And that's one of the problems with the process.
Yeah, I agree. I think the process is very limited, and then there's no immediate appeal. This case was from 2016, so someone like Agnes Chow, if she had an expedited process of review of that decision, could maybe be still a participant in an election, but no process of that nature exists right now, and the returning officer seems to have no hearing process at all.
Can I put to you, Michael Davis, the question I put earlier also about the way that the NPCSE interpretation and the explanation of that interpretation was incorporated into the judgment as well? Are you any thoughts on that?
Well, there was a paragraph in this interpretation. I forget where it was exactly, how it was worded, but essentially referred to the process of running. The NPC itself went back behind the oath taking to how whether a candidate could run, and I think the court relied on that, so that again, sort of they had a path that as Mr. Ma said, where they were sort of bound by precedent of the higher court, which accepts that this NPC interpretation is binding. So again, I think it all comes down to, there's one possibility of appeal, but I'm not sure how far it would go in this case, because the stance of Andy Chan was rather clear on independence. Now, it's of course not so clear when it comes to the self-determination question and the Domicito political party position. And that's another thing to keep in mind, that political young politicians could work their way around this. I think by the self-determination position could be just that Hong Kong people be consulted at the end of the 50 years on whether to continue the one country, two systems model or whatever. So, and I think that's somewhat how it's been articulated by that particular party. So, these kinds of things, I think these are paths to deal with the problem and to get back in the game for these young politicians, but also to restore confidence in the system.
Andy Chan, who should be joining us, I hope, later in the programme himself, is the subject of this election petition, and the ban has said that this is kind of a slippery slope. First it's independents, then it's localists, and then it'll be Democrats. Do you see that happening, Michael Davis, or do you think this is something different in kind? Do you think that his opposition to the basic law is something a little bit more fundamental, and it's not a continuum?
Well, I think it's both. I think his opposition was very clear, as laid out by the court here. So that, I think, was a problem for him in this case, and certainly, as the court described it, why he lost the case. But I think, the slippery slope is very clear, very much a problem here. We've had it over the government's trying to increase sentences for the outspoken activities of many activists. It's trying to bar people from elections. We can't just say it's the returning officer because they consult the Justice Department. So I think the slippery slope, that's exactly why the reputation of Hong Kong is suffering from this, and we've seen the European Union and others, politicians respond to this event. So, I think the slippery slope is a very concerning case, and especially with Beijing behind it, because Beijing's attitude is even probably more stiff than the government's on political opposition. So whether political opposition will be intimidated or not is to be seen, but this is a very serious problem in Hong Kong because of the one country, two systems model and the gap between Hong Kong and the mainland on free speech and basic civil liberties.
Yeah, Carrie Lam has said she's going to be, kind of changing the guidelines to get more clarification around this. I'm wondering, from Wilson and Lawrence, if you could recommend to Carrie Lam what, part of those new guidelines would be that would provide more clarification. What would you include? You're representing the Progressive Lawyers Group. Wilson, Lawrence, the Hong Kong Legal Exchange Foundation. Have your organizations come up with positions, or what would you personally recommend?
No, I haven't. We haven't thought about this yet, but I am quite interested in Professor Davis's idea of an expedited appeal mechanism, because the current problem is that the only way you can challenge the returning officer's decision is through an election petition. And as we've seen from the Chan Ho-tin case, it takes a very, very long time for these things to get decided. His disqualification was almost a year and a half ago. In Agnes Chow's case, if she does a petition, her term would have been over anyways, and it's highly unsatisfactory. So I do think that's an interesting idea to look into.
Okay, Lawrence Marr, do you want to?
Well, with respect to that argument of having giving the candidate an opportunity to explain himself orally in front of a returning officer seems to be a suggestion from Wilson, I think. But it seems that the basic principle is if the returning officer is satisfied that there's cogent evidence and compelling evidence so that he can form a decision, he could go on without interviewing the person. And there is nothing in the law which prohibits the returning officer from interviewing that person if he sees fit. So, if the reform is to rewrite the law, compelling a returning officer to interview the candidate before making a decision, it seems that would be difficult.
Doesn't the ruling say? I can't go through it at the moment, but doesn't it say that they must give an opportunity for the person to have a right of response?
But a reasonable opportunity has to be given, and it could be given on paper. It doesn't have to be. Many of the administrative decisions were decided on paper instead of interviewing the applicant himself.
But as I understand it, in the case of Agnes Chow, there was no opportunity given for a response in person or on paper.
Oh, is that right? I'm not too sure about that case.
Okay, I'm not quite sure the details about that, but that's kind of as it's reported. So, natural justice would suggest you should have a right to reply.
Right.
But again, this would suggest that there's some need for some kind of formalisation of this process. And going back to the question of the speed, justice delayed is justice denied, especially in this case where there is a limited term, and if it's going to take, as it has in this case, a year and a half for the first stage of the response, then that's not justice.
Well, it seems that from other common law systems, there's no expedited what they call election return mechanism. At least in Australia, where I come from, the Court of Disputed Returns always sit months after the election. And the court has wide power to quote interrupt or disturb or overturn an election result at the hearing after the hearing of the election petition matter. So I haven't seen such a mechanism being embraced, and whether that should be a goal for Hong Kong, it really is up to the legislature and very much so the judiciary, because whether they are equipped to deal with that sort of things on an expedited basis.
Do you think, in terms of the evidence that they consider, there should be a statute of limitations on it? I mean, is Andy Chan going to be, 30 years from now trying to run for something, and they say, well, when you were a kid, you said, and I don't think you've changed your mind. Should they be saying, we're only going to look at things you've said in the last 2 years or the last 5 years?
Well, I mean, it comes down to the principle whether you can satisfy the returning officer objectively that there is compelling evidence that you have upheld the basic law and swear allegiance to the HKSAR. I mean, if there is such cogent evidence of a political change, I don't think previous matters or things that you've said would be used against you. Or it may be balanced against what you said just now, but whether it still comes down to the final question is whether you can satisfy them objectively that you have upheld the basic law and swear allegiance to the HKSR.
Wilson, coming down to the final hour. Yeah.
So hang on, let's just hold that thought for a moment as we break for the news at 9 o'clock. We'll be back in 3 minutes to continue the conversation, and we hope that Chan Ho-tin will be joining us then as well from the Hong Kong National Party. And we want to hear your thoughts. Backchat@rthk.hk is our email address. You can call us on 233-88266. We're also going to be talking about blood donation. I know the Red Cross were concerned about levels of blood donation, and there has been a rush and following that tragic accident in Tai Po. More on that later in the programme. The weather, sunny periods, cool this morning, 17 degrees at the moment, relative humidity now at 48%.
Known for some time that this was not true but failed to inform Parliament. You're listening to the news on RTHK.
Welcome back. This is Backchat on a Wednesday morning, Valentine's Day, in fact, with Andrew Wick and me, Hugh Churton. We're continuing to talk about the election petition, which was basically denied in that ruling yesterday. We're talking about the judgment. We have with us Lawrence Ma, who's a barrister, chairman of the Hong Kong Legal Exchange Foundation, Michael Davis, former professor of law at the University of Hong Kong, and Wilson Leung, who's a member of the Progressive Lawyers Group. We're also joined now by Andy Chan Ho-tin, who was the subject of the petition. He's chairman of the Hong Kong National Party. Later we're going to be talking about blood donation in Hong Kong as well. Our email address for comment, drop us a line and we'll read it out. Backchat@rthk.hk, and our telephone number 233-88266. There's our Facebook page as well. That's Backchat on RTHK Radio 3. Put a message there. Everyone can read it and we will read it out on air as well. That's Backchat on RTHK Radio 3. And the email, once again, backchat@rthk.hk. A couple of comments from listeners before we talk to Mr. Chan. First of all, Peter says, I doubt very much that the returning officers are making these decisions independently. These are political and subjective decisions. I believe that different returning officers might take a different view if left to their own devices. I suspect they are in effect acting under instructions rather than advice. If it is the case that the returning officers are acting as messengers, then I would ask, are they failing to discharge their duties properly? In my view, this should be investigated. That comes from Peter. And Alan says, Dear Backchat, we are moving further and further away from any pretense at democracy. Now the CCP is vetoing any opponents from even standing. I'm sure I'm not the first to say that the government preventing people standing from office because of their beliefs, what the government deduces their beliefs are, is literally Orwell's thought crime. The next logical step is to arrest people for crimes they may commit in the future, like Philip K. Dick's pre-crime. Even if one has stated opposition to it, one can follow the law. I personally oppose and have spoken against quite a few government laws and regulations, yet I will not actually break those laws while they are in force. Many politicians have changed their beliefs 180 degrees from when they were young. Student Trotskyites become conservative, hippies become capitalists, and Hong Kong is full of former patriotic subjects of the Queen, with the knighthoods to prove it, now kowtowing to the CCP. If elected, representatives must make an oath to follow the basic law. If they then violate that oath, they can be sanctioned, or in extreme cases, and only in extreme cases, not making remarks that trigger the CCP, removed from office. Thoughts come from Alan. Thank you very much indeed for that. Andy Chan, good morning to you.
Good morning.
Thanks for joining us. Your general reaction to the judgment here?
I regret the judgment, and I disagree with that.
Okay. an outsider might say it's a matter of common sense. Your party has said that it will not follow the basic law. When you make a promise to follow the basic law, you can't be believed. That's just common sense, isn't it?
I think I can uphold basic law while I'm disagreeing with it. I can join the system that's provided by the basic law framework. I'm participating in the framework right now, and I can modify the law. I can promote it. I can advocate the modifying of law while I'm obeying it.
But is there a difference between obeying it and supporting it as a legislative?
I mean, upholding doesn't just mean
not breaking it.
Not breaking it.
Well, basically, according to the law, I need to sign a declaration that upholds basic law, and this is the law requirement, and I fulfill the law. So I think we are going to further. I mean, the returning officer shouldn't go further whether what's it inside the mind of that candidate, because in our opinion, the returning officer should be a mechanical role that do the administrative work, that to inspect whether the documents have been filed and whether the 50,000 have been submitted or not, and that's it. They shouldn't to inspect the mind of the candidates.
But it seems like the judges have said, well, that might have been the previous interpretation by the general public, but this judge's interpretation is, yes, they can make that determination. And so the game has changed, as it were.
Excuse the pardon?
I said the game has changed. People used to think that the role of the returning officer was to tick the boxes and make sure the forms were filled out properly, but the judges said, nope, they can make a broader determination. So now that game has changed. It sounds like you disagree with the judge.
Yeah, of course, we disagree with that because we have called the case in the UK that the returning officer should be an administrative role, but the judge said that Hong Kong is a very special case, so that common law case shouldn't be applied to Hong Kong. And the judge think that the returning officer should have the right to inspect the political stance of the candidate, and we disagree with that. We don't think anyone should be barred from the election because just of their political stance. Because the election is for the Hong Kong people to choose to express whether that political idea should be exist in Hong Kong or not. It should be decided by Hong Kong people, but not the returning officer.
Yeah, there's a lot of sympathy for that view. I'm curious about this point that the judge said this other common law decision doesn't apply here. I mean, I'd be curious to find out what our lawyers online think of that, because the whole point of common law is you look to precedent. Are they going to start throwing out precedent more and more by just saying, we're special, that doesn't apply? I mean, Wilson, Lawrence, Michael, would you like to get in on that?
Well, I think Andy may have misread the judgment, because the common law judgments, particularly McGuinness and the United Kingdom, is applicable, and it has been applied in this case. There are other common law jurisdictions judgments, and I don't see why the judge did not disapply them. And one thing is, I think Andy is advocating the idea that the administrative officer, the returning officer in this case, should perform a mechanical duty, and that's all. But if you look at an example under the issue of nationality, if you sign a declaration form saying that you don't hold any foreign nationality, and then if under Andy's suggestion that the officer is bound by that declaration and cannot investigate further, and upon further evidence being given by a third party that this candidate doesn't just have the Hong Kong SAR passport, it also has a foreign citizenship, then the returning officer has to make a decision based on the evidence provided by the candidate as well as by the third party on the balance of probabilities whether that person has a foreign citizenship. That's what the administrative officer's function is. It is not a mechanical ticking a box function.
Andy Chan?
Yep.
Do you want to respond to that?
Well, how about NS Chow? How about the people who advocate self-determination? How about the people who have never advocate independence, but they represent the other that support independence. Why would they be disqualified? I mean, the standard is only known by the returning officer. The only standard is the returning officer. Whether he believes it or not, he thinks you're not sincere, then you're not sincere. And he is the only standard. I don't think that's objective enough.
Well, I mean, I'm not sure what Michael Davis has to say that, but I mean, under international law, you have to advocate self-determination first, and then to form a government, and then to petition to the United Nations for independence or recognition of the status as an independent country. So the advocating self-determination is a precursor to any independence. So if you're saying that self-determination is segregated or is different or is not independent itself, I think under international law that may not be correct. So someone who advocates self-determination is advocating independence in that sense. So, I mean,
I could respond to that. There's something in that discourse called internal self-determination. So it's not inevitable that someone advocating independence, self-determination, is advocating independence. Many ethnic groups and autonomous regions and so on may have some kind of internal self-determination concept in mind that doesn't seek. Even the Tibetans we know in China are advocating autonomy, a high degree of autonomy or genuine autonomy, and not independence. Even though the Chinese government doesn't accept that. So there's a lot of wiggle room here. And I think in his response, I think he's, someone's nationality is something generally thought to be more clear and more available to an administrative officer. Many of us were concerned that allowing the administrative officer to judge your political beliefs kind of went beyond the mandate of such an official. And his qualification to judge what your political stance was is questionable. The court rejected that. Now, whether Andy intends to appeal and seek a higher court's view on that is still on the table.
Yeah, what about the possibility of an appeal? From what you've been saying, Mr. Chan, from the general reaction, that sounds to me unlikely. It seems that the principle that the returning officer has the right and in fact the obligation to check the validity of any statements made is quite well established. The mechanism maybe that might be subject for review, but the basic principles I think are fairly clear from this. Andy Chan?
Yep. Well, at the end of the day,
are you going to appeal?
We're not talking about the technical issues of the self-determination, and at the end of the day, any idea is just an idea. And how on earth anyone can know what the others is thinking in their mind? So I don't think we need a very objective mechanism to decide whether that guy is sincere or not. But it's not just a decision that made by the returning officer that I believe that you are not sincere. I don't think that's persuasive enough.
Yeah. Will you be appealing?
The question is whether he will appeal.
Sorry. Now, I need to discuss with my lawyers, and I need to seek legal aid from legal aid department, and these are two main factors that whether I will go for appeal or not.
Michael?
Well, that's the only route because the court is rather clear here at the high court level. So, and even citing the European Court of Human Rights on the free speech aspect, interfering with people's expression of opinion has been a concern here as well. So, unless there's an appeal, then these issues won't be teased out, and we won't really have a clear answer to them. But it's still, as I suggested earlier, that's open to the government and the legislature and others to consider whether there should be some process of more prompt review. This has been discussed in countries like India, the United States, and so on. They have procedures for expedited review. So whether that's a move that Hong Kong should consider, and I think it's important because there's so much of this in Hong Kong. If it were just an isolated case, as it is in most jurisdictions, where someone has committed a crime or something and that they're this needs to be reviewed, whether they can run for office. But in Hong Kong, it seems that we're getting a flood of these cases. So Hong Kong's reputation is at stake in this case.
Yeah, and Andy Chan, you said that you think this is a slippery slope. That today it's pro-independence, tomorrow it'll be Demosisto or whatever. Well, it is Demosisto, and the day after it'll be Democrats or something. How would that work? Isn't there a fundamental difference between you and the fact that you don't believe in the very basis of one country, two systems, and the Democrats who do?
I think it's not a legal issue; it's a political issue. We should think on the other side, on the side of CCP. CCP, of course, they want to rule Hong Kong, and we get rid of Hong Kong people. It's a very long-established policy that they only want the place of Hong Kong, but not Hong Kong people. So anyone that advocates democracy, they would not be accepted by CCP. In Hong Kong is very close to a country because we have our own government, our own legislature. If there's a general election of the universal suffrage, of the legislature and the of our chief executive, that will be almost an independent country that wouldn't be accepted by CCP. So when you advocate democracy, you are advocating independence in their mind.
Okay, an email from Bowen who says, Dear Backchat, the recent cases surrounding the issue of disqualifying candidates from running in elections have highlighted 2 points. First, given that candidates who satisfied the basic requirements should be able to run in elections unless proven otherwise, and the government obviously have huge advantages in terms of financial resources, the onus should be on the government to apply to court to disqualify a candidate from running, instead of the onus falling on the candidate who's been disqualified by a returning officer to petition the court to overturn that decision. Secondly, in order that the hugely significant decision of disqualifying a candidate and depriving the electorate of a choice should be made by somebody qualified by experience and training to determine such issues, the relevant provisions in the Electoral Affairs Commission regulations concerning the deadline for nominations should be relaxed to allow for a sufficiently long period between the end of nominations and the election date for the issue to be determined by the court if the government wishes to challenge a candidate's standing. The returning officer's role should thus revert to the previous one of only checking to make sure the procedural requirements are fulfilled, after which the ball will be in the government's court. One of your guests, Professor Wilson, is absolutely correct in saying that Agnes Chow's case is different. She had not, unlike Chan Ho-tin, said anything which clearly meant she would not be capable of upholding the basic law, and she was not even given the chance to explain or respond to the charges made against her. Even Ronnie Tong is on record for saying before the disqualification decision that the position of Agnes Chow and her party should not necessarily bar her from running, and provided that she could explain the terms she used, i.e. self-determination, and make clear that she was not advocating independence, then there would be no problem for her running. The present mechanism of entrusting what's essentially a judicial function to ordinary administrative officers who are not qualified by experience and training to carry out such an important job, and without, it should be emphasised, a sufficiently long period between the end of nominations and election date in which an appeal can be heard by a judge. This is a recipe for abuse and justified dissatisfaction. That comes from Bowen. Wilson Leung, does this mean basically we've got to sort this out? We should. The returning officer does have this duty. We should be more careful about the qualifications of the returning officer, about this mechanism, maybe the timing of it, as Bowen was suggesting there. Do you think that's what's the way forward?
First of all, I'm not sure I agree with what you said earlier, that it's completely clear that the returning officer does have this power. As I said in the beginning, this is the first time that the court has ruled on this. So the binding precedents that I think Mr. Ma was referring to was on other matters. It was not about whether the returning officer has this power. So this is the first time that the court at the high court level has decided that. So there might be a way of appeal on that front. But if this decision is upheld at the highest level, then I certainly do think that the procedures have to be looked at. And one thing the reader referred to, which I do think is worth thinking about, is extending the nomination period. Because right now the nomination period is, I think, 2 to 3 weeks. And it's only about 6 to 8 weeks before the election. And that certainly does not leave enough time for the investigations, looking at Facebook, YouTube, and then possible appeals.
Okay, a couple more comments. Mike says, as I just reread the basic law, just reading the words, the interpretation of which is all dependent upon the Standing Committee's interpretation. That's it. What are we missing? Maybe we should direct all our questions to the Standing Committee, overwhelm them with questions because it seems that they don't want us to think for ourselves. That's Mike's comment on Facebook, and a few more email comments. G says, on the subject of sincerity, quick, somebody invent a sincerometer. When passed over the body, it will play the national anthem, if you're sincere. That's G's take. Sin says, what are the qualifications for a returning officer? Are there previous decisions posted for general viewing? Is a Hong Kong citizen allowed to question the officer's judgment and appeal on behalf of a candidate? And Thomas says, the returning officer and qualification of candidates, this matter of upholding the basic law creates the danger that opposition to the basic law, or to part of it, like to Article 23, that opposition will grow outside of the legislature. This will certainly be a dangerous development for the future of society. And Jalal says, why did the judge take 9 months to decide this case? His judgment is so alarming. He says that upholding the law requires candidates not only to abide and obey the law, but also require them to support and promote the policies of the Central People's Government. Who decides this? Lower government functionaries, employees of the Chief Executive. Let's face it, we've now shed our last vestiges of democracy. Thank you very much indeed for those comments. Lawrence Miles, just to clarify, say on Article 23, if you didn't support Article 23 legislation, would you be allowed to stand?
Well, Article 23 requires you to acknowledge that there is a constitutional duty to enact Article 23. You have to uphold that too. I think you cannot oppose Article 23 because it is a constitutional duty of Hong Kong. Now, as to the content of Article 23 and as to the timing of enactment of Article 23 legislations, basically Article 23 doesn't say. So there's still a lot of room for arguments in that.
The basic law says you have to have a balanced budget. If you have a budget which isn't balanced,
if you advocate for running deficits,
yeah, should be allowed to stand?
No, I don't know what to say to that.
Well, that's why I'm asking you, yeah, because I mean there are all kinds of things in the basic law which you may may be closer to or you may be further away from.
But I think, but Hugh and Andrew, I think the most important thing for us to be satisfied is politically, it is the independence that the central government is of concern.
Well, Carrie Lam has said that she will move to clarify some of these regulations. We'll see what she comes up with.
Yeah.
Yeah. Andy Chan, do you think that you're pretty much done for Hong Kong politics? Do you think there'll ever be a situation where you might be able to run again? Oh, he's long gone.
Okay. Well, thank you very much indeed, anyway, for joining us. To Lawrence Miles Barrister there, to Professor Michael Davis from the University of Hong Kong, Wilson Leung, member of the Progressive Lawyers Group, and to Andy Chan Ho Tin, the chairman of the Hong Kong National Party. Thank you very much indeed for joining us today.